Hello, hello, everybody. Good evening. Welcome. Hello, hello, hello. Happy Wednesday. Made it to the middle of the week, so that's good, right? that's that's positive. We're happy about that. Hello, hello, hello. Good to see everyone. Come on in. I had been trying to get the closing statements, but they are just not up yet. So I will continue to have to wait on those, unfortunately. But that's all right. We'll make do. We'll make do with what we've got. Hello, hello, everybody. Hello. Angry boomers couldn't get to the news. Oh, I'm not sure. What? Any reason? No, I don't think so. I don't think so. But that's just my opinion. Closing statements, yes, right, of course, from the New York versus Trump trial. Hello, hello, hello. Yeah, so I had hoped to do closing statements tonight, everyone, to read through them, but they are just not available quite yet for the New York case. So they really are. There have been a lot of feelings in videos too, in posts. So, but welcome in, everyone. We will do our best. Oh, thank you, everybody. Thank you. Looking forward to this. Yes, well, welcome. These are my nails. These aren't any fancy nails, but I've got. I'm not sure what this color is actually. I don't know. It was very summery. I'll have to look it up. I'll have to look it up. Why were closing arguments so long? Great question, Jesse, and I don't know. Those are a little too long, actually. I think, what was it, 7 hours? I think, or even more than that. 7+ hours of closing arguments is a bit too long. Blue Sparkles, yes. So, I think it's nail polish I got off of Amazon, ILNP, I think, and it's like their glitter. They have a whole bunch of different ones. So I do like to take a break from my fake nails once in a while, especially if I'm going to be playing my guitar for a while. So I've got guitar plans later. Love the blue. Thank you. So I will. 12 hours. Yeah, that's a long time. That's a really long time. So that's too long. That's too long. Yes. Mooncat nail polish. No, I've not tried that. But I've heard of it. I better write it down before I forget, everybody. All right, let me look into that for sure. I'll have to take a peek. Do you sing and play? Yes, I do. And just for enjoyment, not for anyone else to hear. Oh, my goodness. But I do love to play the guitar, so I do not actually have long nails naturally. So I do appreciate that. Cat eye, okay. Closing arguments available. They are not. I have been waiting all day, Hitch. I've been looking and refreshing, but they are just not available yet, everyone. Jury found him guilty of fraud docs with a misdemeanor, not guilty of a felony. So we're going to take a great question, and we're going to take a look here at the jury instructions. It all has to do with how the jury instructions are set out. Now, all the parties have to agree on the jury instructions. About 75% of these instructions are just standard boilerplate for all juries, for all cases. But then we do have this additional piece just for this case. Oh my goodness. Oh, look at that. Thank you so much, John. Oh, that's nice. How long have you played guitar? Well, actually, I started playing in law school. My mom taught me. It was my stress reliever. So not too long. I don't want to count how many years I've been out of law school. So we'll just say, just a couple years. But anyway, I do not think that they actually have a difference here between felonies and misdemeanors for the charges in here. I think it's that unlawful act that is the purpose that bumps it to a felony. So I don't think we have what people have been calling lesser included offenses. So we'll take a look at that as we go through these. Oh, thank you so much. Yeah, I should have grabbed it, but I'll grab it another time. Sorry about that. Yes, I needed a little summary color for today. So we do not have the closing arguments up yet, and which makes sense. That's a lot to transcribe, everybody. But as soon as they do come up, I do plan on reading through them. I think that would be very important. But for tonight, I have the jury instructions, and I thought we could go through some of those. Now, one of the updates that I did see, though, the jury is deliberating, was that they had buzzed twice. So they've buzzed once with one note and then a second note. So the first note that they sent out, they were requesting certain parts of the transcript, so certain kinds of testimony. They had 4 questions on testimony. And then the second buzz, they wanted to hear the jury instructions again. So it was with that the judge said, well, let's go ahead and take a break and come back again tomorrow. So the judge will be reading through those jury instructions with the jury again tomorrow. So I thought this would be a great time to go through these jury instructions. Now, in New York, and probably many other places, you're not really just given this kind of stack of papers. Now, in some jurisdictions you are, but in New York they don't. They read it, and then you go back based off of what you've heard, and you make your decisions. So, that's, in a jurisdiction that doesn't do that, that seems, kind of difficult. But so, of course, they're going to need the jury instructions read back to them probably multiple times, multiple instructions. Yeah, it's, and again, I don't know. New York is one of our original colonies, so, I don't know if it has something to do with that or what. But the further west you go, I don't know. Every jurisdiction has their own set of rules, and there could be some really amazing, great reasons for having it both ways. So I can predict that one thing that they wouldn't want is everyone to really just focus on the packet instead of, kind of talking and deliberating. They're just filling it out like they would an exam. And so, the deliberation process should be one where everyone's kind of talking about things. So I can see why they would do that for sure. But yeah, why do people keep saying the judge didn't allow the defense to call witnesses? I have no idea. There's a lot of incorrect information that's being floated around. So anyway, I thought, and I wanted to have comments on so I could take you through these instructions to the jury and we could talk about them and I could answer questions that people have. So again, this is a white collar crime, everybody, at the end of the day. We're not looking at forcible felonies here. We're not looking at these kind of huge, situations that involve these awful details that will turn your stomach. Well, maybe they will, but not to the level of some of the other ones. So how this court does review that, I don't know. We'll have to see. There's just no way to really tell. But with that, I think the instructions are pretty straightforward here. So Juju, you'll have to take a look at the indictment, and they set it out word for word what exactly the crime is. But we're looking at false entries in business documents. That's the end of it. He had a nap today. Oh, I saw that too. I saw that. Right, it could be, Trisha. All right, so let's go ahead and dive in, everybody. Let's just do these kind of one at a time here. And again, I'll go through and just read through it and kind of talk about what they mean. So here's our first one, post-summation instructions. Now, again, we have different terms depending on our jurisdictions. We would say post-closing arguments. So summations is, pretty old school term that is used. We've got a lot of very old school terms used in New York. Again, I think the further west you go, the more we use a little bit less of that pomp and circumstance, but for each their own. Here's our introduction. Members of the jury, I will now instruct you on the law. I will first review the general principles of law that apply to this case and all criminal cases. You have heard me explain some of those principles at the beginning of the trial. I am sure you can appreciate the benefits of repeating those instructions at this stage of the proceedings. Next, I will define the crimes charged in this case, explain the law that applies to those definitions, and spell out the elements of each charged crime. Finally, I will outline the process of jury deliberations. These instructions will take at least an hour, and you will not receive copies of them. which again is, that's what they do in New York, and I'm sure many other jurisdictions as well. You may, however, request that I read them back to you in whole or in part as many times as you wish, and I will be happy to do so. So, thank you for the gifts, everybody. I really appreciate that. I've used a lot of toner for this trial. Oh my goodness, everyone. The toner. Oh, all right. So there's our introduction that the judge is giving to our jury here, which, again, all of our judges give to all of our juries. Can they take notes? That's a good question. I'm not really sure. I know they can't, they can take notes as they're going through everything and then give them at the end of the day. They have to leave them, and even at the end of the trial, they have to leave them. But I'm not sure if they can take notes during this process. So I really don't know. Oh, thank you, Kristen. That's so sweet. Why do you think they don't give printed instructions in New York? Good question. I don't know if it's tradition or if they just feel that this is the best way for them to be completely focused on the moment, like be in the moment rather than kind of making it into an academic experience, I guess. This judge seems to be more on the ball. I agree. All right, so the role of the court and the jury. Now remember too, everyone, these jury instructions have been approved by both sides and the judge. During these instructions, I will not summarize the evidence. If necessary, I may refer to portions of the evidence to explain the law that relates to it. My reference to evidence or my decision not to refer to evidence expresses no opinion about the truthfulness, accuracy, or importance of any particular evidence. In fact, nothing I have said in the course of this trial was meant to suggest that I have an opinion about this case. If you have formed an impression that I do have an opinion, you must put it out of your mind and disregard it. The level of my voice or intonation may vary during these instructions. If I do that, it is done to help you understand. It is not done to communicate any opinion about the law or the facts of the case or of whether the defendant is guilty or not guilty. It is not my responsibility to judge the evidence here. It is yours. You are the judges of the facts, and you are responsible for deciding whether the defendant is guilty or not guilty. Okay, so fairness, and this is a really key piece, and this really goes back to those original voir dire questions that we had too. Remember, you have promised to be a fair juror. A fair juror is a person who will further. A fair juror must be mindful of any stereotypes or attitudes about people or about groups of people that the juror may have, and must not allow those stereotypes or attitudes to affect their verdict. As I have explained, we all develop and hold unconscious views on many subjects. Some of those unconscious views may come from stereotypes and attitudes about people or groups of people that may impact on a person's thinking and decision-making without that person even knowing it. As a juror, you are asked to make a very important decision about another member of the community. I know you would not want to make that decision based on such stereotypes or attitudes, that is, on what we call implicit biases. And it would be wrong for you to do so. A fair juror must guard against the impact of such stereotypes or attitudes. You can do this by asking yourself during your deliberations whether your views and conclusions would be different if the defendant, witnesses, or others that you have heard about or seen in court were of a different race, color, national origin, ancestry, gender identity, or expression, religious practice, age, or orientation. Or if they did not have a disability. If the answer is yes, then in keeping with your promise to be fair, reconsider your views and conclusions along with the other jurors, and make sure your verdict is based on the evidence and not on stereotypes or attitudes. Justice requires no less. So very important, and really this is pretty new actually, everyone, these requests. And when we're talking about jury instructions, we've had a lot of case law where we've had cases that have been overruled or they've been dismissed, reversed, because jury instructions weren't including something along those lines. So this is relatively new in the legal world. Limiting instruction regarding the defendant. Number one reasons is because it could confuse completing the verdict form. Could be, Russ. Could very well be. That would be an excellent reason. Jurors, you will recall that during jury selection, you agreed that you would set aside any personal opinions or bias you might have in favor of or against the defendant, and that you would decide this case fairly on the evidence and the law. Again, I direct you to decide this case on the evidence and the law as it relates to the defendant here on trial. You must set aside any personal opinions or bias you might have in favor of or against the defendant, and you must not allow any such opinions to influence your verdict. So that's pretty good. All right, sentence, not consider. This is so important, and this is where Todd Blanche was way out of line. This is Law School 101, everybody, and trial advocacy too. Anyone who practices law or is a trial attorney, you know you don't do this. Remember, practices law or is a trial attorney, you know you don't do this. Sentence or punishment. If there is a verdict of guilty, it will be my responsibility to impose an appropriate sentence. That's really important. And actually, it's a violation of our rules to say otherwise. Bifurcation certainly does matter. I'm a big fan of bifurcation. Evidence. When you judge the facts, you are to consider only the evidence. The evidence in the case includes the testimony of witnesses, the exhibits that were received in evidence, and the stipulations agreed to by the parties. Remember, a stipulation is information the parties have agreed to present to the jury as evidence without calling a witness to testify. Testimony which was stricken from the record or to which an objection was sustained must be disregarded by you. So this means even though you heard it, you need to disregard it mentally. All right. Exhibits that were received in evidence are available upon your request for your inspection and consideration. What is bifurcation? It's the splitting of issues. Exhibits that are just seen during the trial or marked for identification but not received in evidence are not evidence and are thus not available for your inspection and consideration. So that's an important piece as well. But testimony based on those exhibits that were not received in evidence may be considered by you. It is just that the exhibit itself is not available for your inspection and consideration. So the testimony is what's important here. All right, next up, evidentiary inferences. In evaluating the evidence, you may consider any fact that's proven and any inference which may be drawn from such fact. To draw an inference means to infer, find, conclude that a fact exists or does not exist based upon proof of some other fact or facts. For example, suppose you go to bed one night when it's not raining, and when you wake up in the morning, you look out your window. You do not see rain, but you see that the street and the sidewalk are wet, and that the people are wearing raincoats and carrying umbrellas. Under those circumstances, it may be reasonable to infer, that is, conclude that it rained during the night. In other words, the fact of it having rained while you were asleep is an inference that might be drawn from the proven facts of the presence of water on street and sidewalk and the people in raincoats and carrying umbrellas, which is a classic LSAT question, everyone. An inference must only be drawn from a proven fact or facts, and then only if the inference flows naturally, reasonably, and logically from the proven fact or facts, not if it is speculative. Therefore, in deciding whether to draw an inference, you must look at and consider all the facts in the light of reason, common sense, and experience. Okay. Next, redactions. So again, we're starting out with just kind of the basic instructions. We will get into those specific to the case here, but I think it's important to kind of take a look at what the overall rules are here. So this is the actual instructions. These are the instructions that have been available to the court. So as you know, certain exhibits were admitted into evidence with some portions blacked out or redacted. Those redactions were made to remove personal identifying information and to ensure that only relevant admissible evidence was put before you. You may not speculate as to what material was redacted or why, and you may not draw any inference, favorable or unfavorable, against either party from the fact that certain material has been redacted. So I think I wanted to, let's just take a minute. If you were on a jury, everybody, and you were given an exhibit and it had redactions on it, do you think you would be able to just focus on the instruction here that says don't worry about it? Or would you be wanting to know what's underneath those redactions? I'm curious to see. Let me pull the chat here. If you had an exhibit and there were redactions in it and the instruction said don't bother with the redactions, would you look at what it was? As long as I understood the context. No, I'm too nosy. I'd want to know. I'd be curious. Okay, I'd want to know what the redactions are. I'd want to see them. I'd want to know. Yes. Okay, well, and I think that's an important point here. Nope, I would. Okay. So I'd want to know everything. I always want to know. Well, I think that's really important because this really is one of the key pieces when we're working on jury instructions and when we're putting a trial together, is that, we know that even though something's redacted and we tell you not to look at it, it's human nature to be curious about what it means and what the context is. So when, as attorneys, even when we argue out our exhibits and we're like, oh, well, this is redacted, so who cares? There are so many things that could be implied that we really have to be careful about what we're putting in, even if it is covered up. So we just, that is something that we do take a look at, that even though we've got an instruction saying, never mind, the redactions behind the big curtain, we know people are going to be curious about it. So we have to make sure to allow for that when we're putting our exhibits in. All right, limiting instructions. All right, so this is where we're getting into the specifics of this case, everyone. These are the instructions that were agreed upon and were necessary during the trial and before and some after, where the judge said we're going to need a limiting instruction because one of the parties requested it. So let's get into those. All right, is a jury allowed to watch the news when they go home to see I would say no, and from the very beginning they were not allowed to watch anything regarding the trial or talk about it or listen to anything. All of that was in the very, very first day. Goes to the rules of evidence as a filter, trying to get distilled reliable evidence. Excellent, absolutely. Being an attorney is so much work. True story. All right, limiting instructions. Here we go. You may recall that I instructed you several times during the trial that certain exhibits were being accepted into evidence for a limited purpose only, and that you were not to consider that evidence for any other purpose. Under the law, we refer to that as a limiting instruction. I will now remind you of some of those limiting instructions you were given during the trial. AMI, you will recall that you heard testimony that while David Pecker was an executive at AMI entered into a non-prosecution agreement with federal prosecutors, as well as a conciliation agreement with the Federal Election Commission. I remind you that evidence was permitted to assist you, the jury, in assessing David Pecker's credibility and to help provide context for some of the surrounding events. You may consider that testimony for those purposes only. Neither the non-prosecution agreement nor the conciliation agreement is evidence of the defendant's guilt, and you may not consider them in determining whether the defendant is guilty or not guilty of the charged crimes. So that's our AMI limiting instruction. Michael Cohen. So this is really important as well. You also heard testimony that the FEC conducted an investigation into the payment to Stormy Daniels and of responses submitted by Michael Cohen and his attorney to the investigation. That evidence was permitted to assist you, the jury, in assessing Michael Cohen's credibility and to help provide context for some of the surrounding events. You may consider that evidence for those purposes only. Likewise, you will recall that you heard testimony that Michael Cohen pleaded guilty to violating the Federal Election Campaign Act, otherwise known as FECA. I remind you that evidence was permitted to assist you, the jury, in assessing Mr. Cohen's credibility as a witness and to help provide context for some of the events that followed. You may Consider that testimony for those purposes only. Neither the fact of the FEC investigation, Mr. Cohen and his attorney's responses, or the fact that Mr. Cohen pleaded guilty constitutes evidence of the defendant's guilt, and you may not consider them in determining whether the defendant is guilty or not guilty of the charged crimes. Right, so there's our limiting instruction for Michael Cohen. Next up, Wall Street Journal news articles. You will recall that certain Wall Street Journal news articles were accepted into evidence during the trial. I remind you now that the articles were accepted and may be considered by you for the limited purpose of demonstrating that the articles were published on or about a certain date and to provide context for the other evidence. The exhibits may not be considered by you as evidence that any of the assertions in the articles is true. Next, other hearsay evidence not accepted for its truth. So everyone, when we were talking about hearsay, hearsay literally is a statement made outside of court being used in court to prove the truth of the matter asserted. And it's a very complicated process, and there's multiple pieces to it. So you need a declarant, you need a statement being made, and you need it outside of court, and you need it being offered for the truth of the matter. So what he's saying here is that it might be hearsay in some reasons, but if it's not being offered for the truth of the matter asserted, technically it's not going to be hearsay then. So he's saying there are some things that were said outside of court, but since it's not being offered for the truth, it's giving context and other reasons, I'm going to allow this evidence to come in. So here we go. And there were other exhibits which contained hearsay and were not accepted for the truth of the matter asserted, but for another purpose, which is an exception to hearsay. For example, there were several National Enquirer headlines and an invoice from Investor Advisory Services. Those were accepted for the limited purpose of demonstrating that the articles were published and the document was created. There were also some text messages that were accepted with a similar limitation. For example, People's Exhibit 171A with respect to Gina Rodriguez's text only, and 257 with respect to Chris Cuomo's text only. Those text messages were accepted for the limited purpose of providing context for the responses by Dylan Howard and Michael Cohen. The exhibits which were accepted into evidence with a limiting instruction are listed here. So they just set out which ones have limiting instructions. So that kind of clarifies that issue. If you have any additional questions or need clarification as to which exhibits were accepted into evidence with limitations, just send me a note with your question and I'll be happy to clarify. So again, that's just another piece of evidentiary issues that we've got to take care of. Presumption of innocence. We now turn to the fundamental principles of our law that apply to all criminal trials, the presumption of innocence, the burden of proof, and the requirement of proof beyond a reasonable doubt. Throughout these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty unless, on the evidence presented at this trial, you conclude that the people have proven the defendant guilty beyond a reasonable doubt. In determining whether the people have satisfied their burden of proving the defendant's guilt beyond a reasonable doubt, you may consider all evidence presented, whether by the people or the defendant. In doing so, however, remember that even if the defendant introduced evidence, the burden of proof remains on the people. So that's very important. Oh, you're welcome, Elle. Of course. So it's very important. And a lot of people ask, what is this beyond a reasonable doubt? And there really is no true definition of beyond a reasonable doubt because it's different for every situation. Defendant did not testify. So this is an instruction we always give in all of our cases. The fact that the defendant did not testify is not a factor from which any inference unfavorable to the defendant may be drawn. And this, of course, is from a U.S. Supreme Court case, the name of which escapes me at the moment, which a lot of these instructions are based off of SCOTUS cases. Burden of proof. The defendant is not required to prove that he is not guilty. In fact, the defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means before you can find the defendant guilty of a crime, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed that crime. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty. And if the people satisfy their burden of proof, you must find the defendant guilty. So I think that's really important to remember also. Sometimes the burden of proof can switch, can cross over during affirmative defenses, like for self-defense and those kinds of things, but those are more administrative issues. Griffin, thank you, Russ. Oh my gosh, you are just on top of it tonight. Thank you very much. Excellent. All right, reasonable doubt. All right. Oh, we love that. We love the case law sites. What does our law mean when it requires proof of guilt beyond a reasonable doubt? The law uses the term proof beyond a reasonable doubt to tell you how convincing the evidence of guilt must be to permit a verdict of guilty. The law recognizes that in dealing with human affairs, there are very few things in this world that we know with absolute certainty. Therefore, the law does not require the people to prove a defendant guilty beyond all possible doubt. On the other hand, it's not sufficient to prove the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be beyond a reasonable doubt. Now, this is where I always get my continuum out to kind of explain, again, the road that we take here. First, we have a reasonable suspicion, right? So these are our burdens of proof. Reasonable suspicion to believe criminal activity is afoot. And then in the middle here, this would be probable cause to believe one person, a particular person, committed a particular offense. This is what we need for warrants. This is also what we need for indictments, all right? Now here is where our civil burden of proof is, and this is upon a preponderance of the evidence here, and that means it's 51% likely a particular person harmed the other person, or they're 51% at fault. All the way down here, all right, is beyond a reasonable doubt. So this is the highest standard that we have, the highest burden that we have of proof for anything in the legal system. It is absolutely the most important, highest burden that one party carries. So just kind of keep that in mind again when you're wondering, what are all these different levels of proof? This is the most difficult level, the hardest burden to meet. All right. So here we go. And again, that's why too, when we're saying here, we're saying probably guilty because that's the probable cause. And of course, beyond a reasonable doubt is more than probable cause. A reasonable doubt is an honest doubt that the defendant's guilt, for which a reason exists based upon the nature and quality of the evidence, is an actual doubt. Is it reasonable to believe that everyone else is lying and the defendant is the only one not lying? I'm not sure. That sounds like dangerous to wade into. Not an imaginary doubt. It is a doubt that a reasonable person acting in a matter of this importance would be likely to entertain because of the evidence that was presented or because of the lack of convincing evidence. So we have this idea now of a reasonable person, everyone, and you've probably heard that reasonable person standard. We don't know what a reasonable person is exactly. There was some standard that used to say, a reasonable person is the fella that, mows his lawn on Sundays in his shirt sleeves and has tomato soup and, drives a Ford, back in the old days, that was the reasonable person standard. So, it depends. It'll depend on the situation. You're a great teacher. Oh, thank you so much. Thank you. So this reasonable person standard, again, is just your average person. So your average run-of-the-mill garden variety person here. Proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of a defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed the crime. In determining whether the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of the evidence. After carefully evaluating the evidence, each of you must decide whether that evidence convinces you beyond a reasonable doubt of the defendant's guilt. Whatever your verdict may be, it must not rest upon baseless speculation, nor may it be influenced in any way by bias, prejudice, sympathy, or by a desire to bring an end to your deliberations or to avoid an unpleasant duty. So this is the moment where I will toss in a very inflammatory term, or maybe not for some people. This is where we have our jury nullification moment. All right, nullification. Spelling, all right, spelling is hard. There we go. So jury nullification, everyone, and we'll do just a quick side route. Jury nullification means that rather than looking at the evidence and using the law, you are being influenced by your sympathy or by something else. Typically, it's sympathy. So you may think, well, yes, this person violated the law, but the law is awful. This law is wrong. And so although they did commit the crime or did whatever, we're not going to convict because our sympathy says that it's the law that's wrong rather than the defendant. So this is one of the pieces that we look at when we look to jury nullification. If you are not convinced beyond a reasonable doubt that the defendant is guilty of the charged crime, you must find the defendant not guilty of that crime. And if you are convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, you must find the defendant guilty of that crime. Got a lot of attention during yeah, I think so. It's making a comeback. It's never been gone, but I think it goes in waves. The nullification arguments. Is convicted of felony, can he still run for president? Yes. There's nothing in the Constitution that says you cannot be a convict and then run for president. We don't have any of those restrictions. Credibility of witnesses. So let's dive into that. All right, introduction. As judges of the facts, you alone determine the truthfulness and accuracy of the testimony of each witness. You must decide whether a witness told the truth and was accurate or instead testified falsely or was mistaken. You must also decide what importance to give to the testimony. You accept as truthful and accurate. It is the quality of the testimony that's controlling, not the number of witnesses who testify. Except in whole or in part, so falsus in uno. So this is also another instruction that can be pretty typical. If you find that any witness has intentionally testified falsely as to any material fact, you may disregard that witness's entire testimony. This is actually a pretty powerful instruction. So any fact that you think that they lied about means you can disregard all of their testimony. Or you may disregard so much of it as you find is untruthful and accept so much of it as you find to have been truthful or accurate. So I think this really summarizes the entire question that we have with Mr. Cohen. How much are we going to believe? Are we going to believe all of it, a little bit of it, some of it, only the things that weren't true, only the things that he came back and said, sorry, this is true? So I think this is like the Michael Cohen question when we're talking about how much to believe a particular witness. It's right here. Next, credibility factors. There's no particular formula for evaluating the truthfulness and accuracy. Hold on, everybody. Hopefully, am I in frame okay, everyone? I've got a couple screens here. One screen is saying I'm okay. The other one's kind of off a little bit. So hold on here. Let me just make sure. Okay. Hopefully that's okay. Okay, thank you. Thank you, Claude. Thank you, Jennifer. Appreciate it. Yes, okay, Sass. Excellent. All right, so credibility factors. There's no particular formula for evaluating the truthfulness and accuracy of another person's statements or testimony. You bring to this process all of your varied experiences. In life, you frequently decide the truthfulness and accuracy of statements made to you by other people. The same factors used to make those decisions should be used in this case when evaluating the testimony. In general, some of the factors that you may wish to consider in evaluating the testimony of a witness are as follows. Did the witness have an opportunity to see or hear the events about which he or she testified? Did the witness have the ability to recall those events accurately? Was the testimony of the witness plausible and likely to be true, or was it implausible and not likely to be true? Was the testimony of the witness consistent or inconsistent with other testimony or evidence in the case? Did the manner in which the witness testified reflect upon the truthfulness of that witness's testimony? To what extent, if any, did the witness's background, training, education, or experience affect the believability of that witness's testimony? Next, did the witness have a conscious bias, hostility, or some other attitude that affected the truthfulness of the witness's testimony? This was what Todd Blanche was hammering so hard on when it came to Michael Cohen. He kept saying, this witness has bias, and I want to show this to show bias over and over and over again. So this is what he's talking about, is what is set out as one of the factors in determining the credibility of a witness here. All right. Did the witness show an unconscious bias? That is, a bias that the witness may have even unknowingly acquired from stereotypes and attitudes about people or groups of people. And if so, did that unconscious bias impact that witness's ability to be truthful and accurate? So there we go. And motive. So, again, we've got motive, benefit, and interest. These are continuing on factors for credibility. You may consider whether a witness had or did not have a motive to lie. If a witness had a motive to lie, you may consider whether and to what extent, if any, that motive affected the truthfulness of that witness's testimony. If a witness did not have a motive to lie, you may consider that as well in evaluating the witness's truthfulness. All right, so there we go, motive. And then next up is benefit. You may consider whether a witness hopes for or expects to receive a benefit for testifying. If so, you may consider whether and to what extent it affected the truthfulness of the witness's testimony. So in this particular case, I can think of a couple of witnesses that benefited, right? So we had, of course, Mr. Pecker benefited. He had this agreement that if he testified, then he wouldn't have charges brought against him. Was Mr. Pecker the only one that had a benefit for testifying? I'm wondering. The only other benefit that seemed to be argued was some kind of a monetary benefit for Miss Daniels. Right, already, exactly, Russ. Yep, they already benefited from it and could continue to by having their names, in the spotlight, I suppose. I think it's an interesting point. What's the benefits to testify? Didn't Cohen get a sweetheart deal on his case? Now that's a good question, and I don't know. I'm not sure. Costello, but outside of court, perhaps so, perhaps. Well, I think that's good to note. And, as the jurors are listening as well, they're already thinking of that. If you were a juror sitting on this case, you would immediately, as soon as a witness came in, one of the first things you would think of is like, okay, well, what's their motivation for testifying? So I think that's important to note. Interest, lack of interest. You may consider whether a witness has any interest in the outcome of the case, or instead whether the witness has no such interest. You are not required to reject the testimony of an interested witness or to accept the testimony of a witness who has no interest in the outcome of the case. You may, however, consider whether an interest in the outcome or the lack of such interest affected the truthfulness of the witness's testimony. Testified he couldn't get his sentence reduced, but he did get COVID release. Yes, that's right. I'm not really sure. I think Cohen definitely, there were some benefits for him kind of to go forward with his brand. If we're going to go down that road, like his brand is the mea culpa, right? Like I need to come in and make everything right for the mistakes I made. So this was kind of like, adding to that whole shtick. Not that it's a bad shtick. I'm just saying, that could be one of the benefits that someone may see. If I was a juror, oh, I know. And this is just being read to them, everyone. All right. Previous criminal conduct. You may consider whether a witness has been convicted of a crime or has engaged in criminal conduct, and if so, whether and to what extent it affects your evaluation of the truthfulness of that witness's testimony. You're not required to reject the testimony of a witness who has been convicted of a crime or has engaged in criminal conduct, or to accept the testimony of a witness who has not. You may, however, consider whether a witness's criminal conviction or conduct has affected the truthfulness of the witness's testimony. I think he did try to sue Cohen. Do they get to know if the witnesses are compelled or voluntary? That's all brought out during cross-examination. So, and a good attorney would put that on during direct. And when we went through the testimony, right away with Mr. Peckard, the question was, was a deal made? Yes. And what was that deal? So for each of them, that's just brought out in front of them. I don't understand what. Yeah, I know. Inconsistent statements. You may consider whether a witness made statements at this trial that are inconsistent with each other. You may also consider whether a witness made previous statements that are inconsistent with his or her testimony at trial. You may consider whether a witness testified to a fact here at trial that the witness omitted to state at a prior time when it would have been reasonable and logical for the witness to have stated the fact. In determining whether it would have been reasonable and logical for the witness to have stated the omitted fact, you may consider whether the witness's attention was called to the matter and whether the witness was specifically asked about it. If a witness has made such inconsistent statements or omissions, you may consider whether and to what extent they affect the truthfulness or accuracy of the witness's testimony here at trial. The contents of prior inconsistent statements are not proof of what happened. You may use evidence of a prior inconsistent statement only to evaluate the truthfulness or accuracy of the witness's testimony here at trial. Okay, consistency. Here we go. You may consider whether a witness's testimony is consistent with the testimony of other witnesses or with other evidence in the case. If there were inconsistencies by or among witnesses, you may consider whether they were significant inconsistencies related to important facts or instead were the kind of minor inconsistencies that one might expect from multiple witnesses to the same event. Witness pretrial preparation. You have heard testimony about the prosecution and defense counsel speaking to a witness about the case before the witness testified at this trial. The law permits the prosecution and defense counsel to speak to a witness about the case before the witness testifies, and permits a prosecutor and defense counsel to review with the witness the questions that will or may be asked at trial, including the questions that may be asked on cross-examination. You've also heard testimony that a witness read or reviewed certain materials pertaining to this case before the witness testified at trial. At least you hope they have. All right, I'm going to pause for a moment. To all my law enforcement out there, if you're listening, please, I beg you, read your report before you come to court. Thank you. That's my public service announcement for the moment. Thank you for everything you do. The law permits a witness to do so. Speaking to a witness about his or her testimony and permitting the witness to review materials pertaining to this case before the witness testifies is a normal part of preparing for trial. It is not improper as long as it's not suggested that the witness depart from the truth. Oh, thank you so much, GH. Oh, we love that. Thank you for your hard work. Identification. The people have the burden of proving beyond a reasonable doubt not only the charged crime was committed, but that the defendant is the person who committed that crime. Thus, even if you are convinced beyond a reasonable doubt that a charged crime was committed by someone, you cannot convict the defendant of that crime unless you also are convinced beyond a reasonable doubt he is the person who committed that crime. Okay. All right, accomplice as a matter of law. So this again is another Michael Cohen road that we're going to go down here. All right. Under our law, Michael Cohen is an accomplice because there's evidence that he participated in a crime based upon conduct involved in the allegations here against the defendant. Our law is especially concerned about the testimony of an accomplice who implicates another in the commission of a crime, particularly when the accomplice has received, expects, or hopes for a benefit in return for his testimony. Therefore, our law provides that a defendant may not be convicted of any crime upon the testimony of an accomplice unless it is supported by corroborative evidence tending to connect the defendant with the commission of that crime. So this means, everyone, I'll just pause for a moment, that if you have an accomplice and that's all the evidence that you have nothing else, that's not going to be enough to take it to the finish line. In other words, even if you find the testimony of Michael Cohen to be believable, you may not convict the defendant solely upon that testimony unless you also find it was corroborated by other evidence tending to connect the defendant with the commission of the crime. The corroborative evidence need not by itself prove that the crime was committed or that the defendant is guilty. What the law requires is that there be evidence that tends to connect the defendant with the commission of the crime charged in such a way as may reasonably satisfy you that the accomplice is telling the truth about the defendant's participation in the crime. In determining whether there is the necessary corroboration, you may consider whether there is material, believable evidence, apart from the testimony of Michael Cohen, which itself tends to connect the defendant with the commission of the crime. You may also consider whether there is material, believable evidence, apart from the testimony of Michael Cohen, which, while it does not itself tend to connect the defendant with the commission of the crime charged, it nonetheless so harmonizes with the narrative of the accomplice as to satisfy you that the accomplice is telling the truth about the defendant's participation in the crime, and thereby tends to connect the defendant to the commission of the crime. Right. All right, here we go. I now instruct you on the law applicable to the charged offenses. The offense is falsifying business records in the first degree, 34 counts. So here we go. Accessorial liability. Our law recognizes that two or more individuals can act jointly to commit a crime, and that in certain circumstances each can be held criminally liable for the acts of the others. In that situation, those persons can be said to be acting in concert with each other, like Mr. Menendez. We'll just use that as an example. Our law defines the circumstances under which one person may be criminally liable for the conduct of another. That definition is as follows. When one person engages in conduct which constitutes an offense, another is criminally liable for such conduct. When acting with the same state of mind required for the commission of that offense, he or she solicits, requests, commands, importunes, or intentionally aids such person to engage in such conduct. Under that definition, mere presence at the scene of a crime, even with knowledge that the crime is taking place, or mere association with the perpetrator of a crime, does not by itself make a defendant criminally liable for that crime. In order for the defendant to be held criminally liable for the conduct of another which constitutes an offense, he must find beyond a reasonable doubt, 1, that he solicited, requested, commanded, importuned, or intentionally aided that person to engage in that conduct, and 2, that he did so with the state of mind required for the commission of the offense. Tea break. Thank you, C. Marie. All right, so here we go. If it is proven beyond a reasonable doubt that the defendant is criminally liable for the conduct of another, the extent or degree of the defendant's participation in the crime does not matter. So that's important, everyone. The extent doesn't matter. A defendant proven beyond a reasonable doubt to be criminally liable for the conduct of another in the commission of a crime, and that's the key phrase again, the commission of a crime, is as guilty of the crime as if the defendant personally had committed every act constituting the crime. Now, this is a concept that is very difficult for a lot of people to kind of wrap their head around. So the commission of a crime, right? The commission of the crime was to make it to, right, we've got campaign contribution, right, that was not properly declared, and also this attempt to keep information from the public about a candidate who's running for president. Those you would say are done by Michael Cohen. It doesn't matter. If he was committing a crime, it's as though the defendant was committing the crime himself. All right? Guilty. Exactly right. Exactly. Oh, thank you, Mike. I appreciate you too. Thanks for stopping by. So this is the key. It doesn't matter exactly what piece the juror believes. All they need to believe is that Michael Cohen committed an offense, and then that will be the same as if the defendant committed the offense. All right? So next up, the people have the burden of proving beyond a reasonable doubt that the defendant acted with the state of mind required for the commission of a crime, and either personally or by acting in concert with another person committed each of the remaining elements of the crime. Your verdict on each count you consider whether guilty or not guilty must be unanimous. So for each count, all right, I've gotten that question a lot. Does it, do they have to find him for all the counts? Every count has to have a yes or a no, all right? You have to find guilty or not guilty for each count, but you don't have to find all 34. They could find 10, or they could find 5, or they could find 32. It doesn't matter. Each count is separate. It's just per count needs a guilty or not guilty added to it. So, and then it has to be unanimous per count. The number of counts don't matter. It's per count. It's unanimous guilty or not guilty. Wasn't that technically already found since he was found guilty before? Well, technically, yes, but we have a limiting instruction. We have a limiting instruction when it comes to Michael Cohen's criminal record. So we do have to kind of watch out for that. And the actual details of what he was convicted of was a huge fight. So that also was not necessarily put in there. So the fight between the state and defense counsel was exactly what Michael Cohen was found guilty of, because we have this situation where if you give the details that he was found guilty of something that Trump told him to do, that Trump was involved in, then you would have this very negative inference. So we had to step very carefully through that. However, you need not be unanimous on whether the defendant committed the crime personally or by acting in concert with another or both. All right, so each one of these, if he didn't sign the check himself, that's okay. If somebody else signed the check in his stead, that's fine. That's what they're saying here. And I think we had two checks that were signed by various other people. The charged crimes. All right, so, oops, I got a puzzle piece, everybody. We got to verify that we're on a live. Whoops. Uh-oh. Here we go. Wish me luck. Did we get it? Oh, we got it. Yay! All right. Yes, we are on a live. Oh, my goodness. All right. Here we go. Let's get ourselves sorted out here. All right. So, for charged crimes, I will now instruct you on the law applicable to the charged offense. That offense is falsifying business records in the first degree, 34 counts. Falsifying, Penal Law Section 175.10. We're alive on a live. We certainly are, Mads. Yay! I'm a real person. Yes, you most certainly are. Under our law, a person is guilty of falsifying business records in the first degree when, with the intent to defraud that includes an intent to commit another crime. This is that felony piece, all right? Or to aid or conceal the commission thereof, that person makes or causes a false entry in the business records of an enterprise. The following terms used in that definition have a special meaning. Enterprise means any entity of one or more persons, corporate or otherwise, public or private, engaged in business, commercial, professional, industrial, social, political, or governmental activity. All right. Business record means any writing or article, including computer data or computer program, kept or maintained by an enterprise for the purpose of evidencing or reflecting its condition or activity. So this is where our documents come into play here. Now, intent is one of the fighting elements here that we had going on. So, of course, and we have a A silly ask. Oh, I know, right? What's the crime? What's the crime? Well, All right. So in order to have a crime, we need to have an act plus the intent. All right? That equals our crime. And then, so you have a crime, it was committed, and then you subtract any defenses from that crime. All right? That's our criminal equation. So the act itself, the intent, it equals a crime, and then you subtract defenses. So the intent element is 50% of the situation. So we have to make sure that our intent element is found. Intent means conscious, objective, or purpose. Thus, a person acts with intent to defraud when his or her conscious objective or purpose to do so. Intent does not require premeditation. In other words, intent does not require advanced planning, nor is it necessary that the intent be in a person's mind for any particular period of time. Now, again, this is for this case. The intent can be formed and need only exist at the very moment the person engages in the, I'm sorry, that was my cat, engages in the prohibited conduct or acts to cause the prohibited result, and not at any earlier time. So if we were to break this apart, again, just kind of explaining how intent works, if we were to look at homicide, premeditated versus heat of passion are levels for homicide versus manslaughter, all right? So that's how we would break those apart. We break homicide apart based off of intent. Planning, premeditation, heat of the moment, manslaughter is everything else. Yes, bless you, Paralegal. Are you okay down there, Atticus? Are you all right, buddy? All right, he's all right. He put his mouse in his water dish, so he sneezes sometimes trying to get his mouse out. All right. The question naturally arises as to how to determine whether a defendant had the intent required for the commission of a crime. To make that determination in this case, you must decide if the required intent can be inferred beyond a reasonable doubt from the proven facts. In doing so, you may consider the person's conduct and all of the circumstances surrounding that conduct, including but not limited to the following. What, if anything, did the person do or say? What result, if any, followed the person's conduct? And was that result the natural, necessary, and probable consequence of that conduct? Therefore, in this case, from the facts you find to have been proven, decide whether you can infer beyond a reasonable doubt that the defendant had the intent required for the commission of the crime. Intent to defraud. As I previously explained, a person acts with intent to defraud when his or her conscious objective or purpose is to do so. In order to prove an intent to defraud, the people need not prove that the defendant acted with the intent to defraud any particular person or entity. A general intent to defraud any person or entity suffices. This is the key right here, all right? So general intent, we've got two levels of intent that we're dealing with. We have general intent crimes and we have specific intent crimes. So specific intent meaning I am intending for this action to happen based off of what I'm doing. A general intent is I've just got this overall desire to defraud as opposed to specifically about it. So this idea of having this just general intent is very different from the specific intent required for other crimes. So a general intent to defraud any person or entity suffices. So at this point, let's bump down to the next one and then I'll come back. Intent to defraud is also not constricted to an intent to deprive another of property or money and can extend beyond economic concerns. So let me pause for a minute. A general intent to defraud any person or entity suffices. So that's the question. So let me ask the chat, everybody, what would be Mr. Trump, hypothetically, Mr. Trump's general intent? What was his general intent? What was it to do? Was his intent to, who was he trying to defraud? What was he trying to do? Defrauding the public. Right. To win the election. The general intent Right, exactly. To hide the payment, to cover his character, to become president, to cover his actions, to affect the election. In the South, the voters, to defraud the voters. A general intent to keep information from the voters. Oh, thank you, Mads. Okay. Analogy on burglary she uses on Midas Touch about this. Oh, right. Yes, I think that's a great. Okay, yeah, we got it. To hide criminality. Right. So, I'm trying to think if I can remember her analogy. I might steal it from her. Hold on, let me think for a minute. So you had burglary as a general intent. I can't remember what her analogy was. I apologize. But yeah, so there you go. So you have a general intent to do wrong versus a specific intent to do something wrong. So I think her analogy, again, and I'm not going to take credit for it, was if you're, burglarizing, which means you're going into a place in order to steal something. So you may not know what it is that you're trying to steal. Like you may not say, I know that this house has the Maltese Falcon and I'm going to steal it, like a grand burglar. But you might just say, wow, this house looks wealthy and I'm going to go inside and see what I can find. So the general intent is to pull something out of the home that doesn't belong to you. So that's a theft. But the specific intent would be if you actually had something specifically in mind. Right. And the intent of what it is they're trying to steal isn't as important as the point that they're going in to steal something. Comment to pin closing arguments PDF. Really? Oh my gosh, VC. Okay, everybody. Oh my gosh, closing arguments. All right, so should we, okay, also do defraud campaign. Right. Yeah, so again, I mean, I'm here to cause general trouble versus, I'm here to, I always use this analogy. It's between a baseball bat. What kind of damage can you do? That's general intent versus specific intent, which is a scalpel. Like I know exactly the kind of damage I'm going to do. No, they do not get a copy of the instructions. Right. Right. All right, well, hold on, everybody. Let me at least take a real quick peek here. Just one moment. I have been waiting for those, closing arguments. Hold on here. All right. Those paralegals or those stenographers are working so hard. Oh my goodness. All right, everybody, hold on. I'm going to just print the first little bit here. Just a second. Okay. Yay! Oh, so exciting. Thank you so much, BC. All right, so I will go ahead and print just the beginning. We can at least look at the beginning of his closing statement. So I've been after that. Very important. All right. Because of the length, yes, I agree. Well, I think I would like to do just the very beginning, but then after that, I'm going to have to be careful. How does the jury not get a copy? Yeah, it's a good question. It's an excellent question. All right. So Right, right. All right, everybody. So we talked about this general intent versus specific intent. So that's what they're really looking at. Next, we've got intent to conceal or commit or conceal another crime. For the crime of falsifying business records in the first degree, so this is the first degree, this what makes it a felony. The intent to defraud must include an intent to commit another crime or to aid or conceal the commission thereof. Under our law, although the people must prove an intent to commit another crime or to aid or conceal the commission thereof, they need not prove that the other crime was in fact committed, aided, or concealed. So this is the piece that is important. Just that there was an intent to commit another crime. What that crime was, it doesn't really matter. If it was not properly putting down your campaign finances, if it was not properly giving information to the public, it doesn't matter. All it has to have is another crime. Any other kind of crime can be involved here. Okay, hold on, everybody. My printer just yelled at me. Just a second. All right, well, we'll see. We'll see if this comes out or not. Oh, my goodness gracious. All right, so that's what makes this first degree, and this is a Class E felony as opposed to a misdemeanor. So let's look, and again, I don't think we have that lesser included offense included here. So without a lesser included offense instruction, that's not another option. You have to have that in order for the jury to even consider it. So let's take a look and see if we've got that. Printer's yelling for mercy. Oh, I know. I know, my printer. Oh my gosh. Well, sometimes Pearl gets into the printer and I have to get her out. I'm like, get out. We'll see. We might have to move the closing to tomorrow. We'll see. I'm not sure. All right. So next we have by unlawful means. Oh, wait, I flipped too soon. Hold on, everybody. So a predicate act, we had some of that discussion that came out earlier from Mr. Blanche. The people allege that the other crime the defendant intended to commit, aid, or conceal is a violation of New York election law section 17152. All right, so the New York election law provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of conspiracy to promote or prevent an election. Well, that's interesting how that law is written. All right. Conspire to promote or prevent the election of any person to a public office by unlawful means. So with intent that conduct be performed that would promote or prevent the election of a person to public office by unlawful means, he or she agrees with one or more persons to engage in or cause the performance of such conduct. Knowledge of a conspiracy does not by itself make the defendant a co-conspirator. The defendant must intend that conduct be performed that would promote or prevent the election of a person to public office by unlawful means. Intent means conscious objective or purpose. Thus, a person acts with the intent that conduct be performed that would promote or prevent the election of a person to public office by unlawful means when his or her conscious objective or purpose is that such conduct be performed. All right. So here, again, we're trying to, with this whole situation, we can see that we're trying under the New York law to promote a particular person through unlawful means by prohibiting certain information from being made public, and doing that by not properly labeling the campaign contribution. right? So by Stormy Daniels not telling her story, that would be campaign assistance. And in order for you to have any campaign assistance, you have to write that out. We have to know about it. Like, it's okay if you want to, tell someone, here's some money. Don't talk about stuff, but you have to declare it as a campaign contribution, because we need to know what all the campaign contributions are. So interesting how our campaign law works. Yeah, I think it's very interesting. All right, so evidence that the defendant was present when others agreed to engage in the performance of a crime does not by itself show that he personally agreed to engage in the conspiracy. By unlawful means, although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to public office by unlawful means, you need not be unanimous as to what those unlawful means were. In determining whether the defendant conspired to promote or prevent the election of any person to public office by unlawful means, you may consider the following: violations of the Federal Election Campaign Act, known as FECA, the falsification of other business records, or violation of tax laws. So I think this is interesting because basically the state's saying, like, it's juror's choice. It's your choice. Pick the crime. Pick which crime you are most comfortable saying that he was trying to commit. So it's your choice. Here you go. 1, 2, or 3. Because any of these means then that we had an unlawful purpose. And that's what gets you to that felony. That's what gets you to the first degree. All right. So they're giving them 3 options of which law they believe Mr. Trump was attempting to violate. Yes, I think that's great too. I think so. Hold on, my printer. Oh my goodness gracious. Yikes. Okay, we have it. Woohoo, we have it, everybody. All right, so let's go ahead and put pause. We'll pause here on our jury instructions. And we're about halfway through, which was really my goal. I felt like that would be plenty. And then I will just get started on the closing argument. I just kind of want to look at his beginning. I will not go through his entire, that's hours and hours. But I would like to get kind of those first few pages read. I've been waiting patiently for them. So if everyone is okay with that. Right. Thank you, Marina. Made it so complicated. Did we already talk about the gag order denial? No, not yet. I'm going to have to make a yikes. That's a yikes moment for me with that. So Judge Cannon's like, ugh. I saw some reporting on what exactly had happened during that hearing that Judge Cannon had told the state to calm down, and it's like, oh dear, oh dear, oh dear. All right, everyone, tap for toner. Oh my gosh. It's still warm, everybody. It's still warm. Oh my gosh, oh my goodness. All right, everyone. So many cliffhangers. Oh, I know, right? I know. Oh, prosecution did a great job. I think so too. Okay, everybody. So, as I had hoped to do, I would like to read just a few pages, just a couple pages here of the closing arguments. So, in the Trump case, now, obviously it's the Trump case. Now, we only have literally just a couple of moments here when the judge comes in, and then Mr. Blanche comes in and starts talking. So the judge asked him originally, how long is your argument going to be? And he says, I believe 2.5 hours, maybe a little under that, which is not true. So I will just dive right in to his argument here. So I'm flipping through the jury, the good morning speech to the jurors here. Okay. Again, this is the judge talking to the jury right now. All right, here we go. Here's the start. All right, I'm gonna just grab, I just saw a couple more pages, so this will be my last grab here. All right, here we go. Mr. Blanche, closing arguments. Let's go ahead and switch up to another pen. All right, let's see here. All right, there we go. Let's get into frame. All right, let's get the popcorn out. All right, everybody, here we go. Mr. Blanche and his closing statement. Thank you, Your Honor. I'm sorry, I'm just confirming something. All right, good morning, ladies and gentlemen. I hope that everyone had a nice long weekend. I want to start with something that I can say, I think with confidence, that everybody inside, oh, thank you so much, oh my gosh, this well agrees with, which is just to thank you for your jury service. You guys, every one of you, have been there on time, and we see you paying close attention to the evidence all day, every day, and we really appreciate that. Okay, Mojo was speaking, that's right. Our criminal justice system, as Judge Merchan just told you, is unique. There is not a lot of justice systems in the world like ours, where a group of citizens like you all actually decide the facts. It's not the prosecution, it's not the judge, it's not a group of judges. It's you all that decide the facts. And each of you will decide at the end of this case whether President Trump is guilty or not guilty. And when I stood here 5 weeks ago on April 22nd, I started out by saying something that I'm going to repeat to you right now, because it's as true right now as it was on April 22nd. And that is that President Trump is innocent. He did not commit any crimes. And the district attorney has not met their burden of proof, period. The evidence is all in. It all came in as of last Tuesday. And that evidence, like I said to you on April 22nd, should leave you wanting more. You should want and expect more than the testimony of Michael Cohen. You should want and expect more than Deb Tarasoff telling us how she booked certain invoices and how she vouchered certain evidence on personal records of President Trump, something beyond the word of a woman who claims that something happened in 2006. Yikes. Oh dear. It's not very nice. You should demand more than the testimony of Keith Davidson, an attorney who really was just trying to extort money from President Trump in the lead up to the 2016 election. And there are consequences, the consequences of utter lack of proof that you all heard over the past 5 weeks is simple. It's a not guilty verdict, period. Now this morning I'm going to spend some time talking to you about the evidence that you all saw over the past 5 weeks. But it's also not just about what you saw and what you heard in this courtroom, but also what you didn't hear. This case is about documents. It's a paper case. This case is not about an encounter with Stormy Daniels 18 years ago, an encounter that President Trump has unequivocally and repeatedly denied ever occurred. It's not even about the confidential settlement in 2016 with the non-disclosure agreement with Stormy Daniels that was signed nearly 8 years ago. It goes to the charges, the reason why we're here. The reason why you're all here is whether and to what. Oh, I'm so excited to find out what the reason is that we're all here, everyone. And what extent President Trump, while he was living in the White House as the leader of the free world, whether he had anything to do with how payments to Michael Cohen, his personal attorney at the time, were booked on his personal account and ledger at Trump Tower. Is the booking of legal expenses on the personal ledger of President Trump accurate? Were those bookings done with an intent to defraud? That's why you're here. And the answer to those questions are absolutely positively not. The bookings were accurate and there was absolutely no intent to defraud. And beyond that, there was no conspiracy to influence the 2016 election by President Trump, the folks at AMI, Michael Cohen. The proof there doesn't add up. And we're going to talk about that this morning. All right, let me pause for a minute. I'm going to just pause for a minute, everybody. Oh my gosh, Dave, you just said exactly what was in my head. If it didn't occur, why did he reimburse Cohen? But the other question too that I have, everyone, all right, if it wasn't a big deal, like why did you rush to pay her? I mean, why did she have to be paid so quick? You know, like she talked about her story and then like 2 days later she got paid. Like what was the rush? What was the big rush if there wasn't anything that was important going on? That's my other question. What was the rush? Why are we in such a hurry to pay her for her story if it wasn't a big deal? Oh, T, thank you. Oh my goodness. Well, right. Exactly, Suze, exactly. All right, so, what's the hurry? It's no big deal. All right, let's talk about the evidence. Ooh, let's do that. I'm going to try to use a pointer, and if I fail, then Mr. Sitko will stand in for us. Whereupon, a PowerPoint presentation containing exhibits and excerpts are shown on the screens throughout the entirety of the following summation. Oh my gosh. All right, here we go. This is what I was talking about. These are the charges that you ultimately have to find. And as Judge Mershon just told you, I'm not going to talk about the law. That's the judge's job. But if I do say anything about the law, if Judge Mershon says something different, his word controls, of course. The bottom line is the charges in this case have to do with invoices, vouchers, and checks. The invoices were all submitted by Michael Cohen, and I'm going to stop. You're going to hear me talk a lot about Michael Cohen today. That should not surprise you. You cannot convict President Trump. You cannot convict President Trump of any crime beyond a reasonable doubt on the words of Michael Cohen. There were key conversations, key interactions that he claimed that he had with Dylan Howard and with Keith Schiller, Alan Weisselberg. Those are important. But Keith Schiller, Dylan Howard, and Alan Weisselberg were not witnesses in this trial. Michael Cohen is a witness that they called. And the words that Michael Cohen said to you on that stand, they matter. They matter. He took an oath. He swore to tell the truth. And He told you a number of things on that witness stand that were lies, pure and simple. Now, the records that we are talking about here that are on the screen, those are not, as you all know, they are not 2015 records. They are not 2016 records. These are all records that were generated by folks in 2017 when President Trump was in the White House. You heard that when he was there, he was working from early in the morning until late at night, as you would expect. I don't know. I don't know. Because he fell asleep a lot during trial. I'm not sure. And the checks that he signed, which we are going to talk about, he signed when he was at the White House. Now, there are two things that I expect that you won't find as it relates to these documents. First is that the documents contained false entries, and second, that President Trump acted with an intent to defraud. Those are not the only two elements that are at issue in the case, but those are the elements that are at issue with the documents. And I'm going to start with those two because in some ways you don't have to go further. Those records are not false, and there was no intent to defraud. What? So let's talk about the invoices. Wait, I don't get what he's doing here. I'm waiting. I'm trying to follow Mr. Blanche down his road here. I'm waiting. I'm waiting here. Those invoices, as you all know and remember, were prepared and sent by Michael Cohen and then the accounting staff at Trump Tower. Just put the stamp on them, as you can see on the screen here. Then there were the vouchers. And the vouchers, as you know, were prepared by Ms. Tarasoff, who testified. She told you that she and Jeff McConney used a system called MDS. Do you remember that Monday when both of them testified and they talked about the accounting software that the Trump organization used called MDS? And the vouchers, the information that was put in those vouchers were a result of what the invoices said, right? Do you remember she told you that? Art, is he cross-examining the jury? Oh my goodness. That she saw the invoice from Mr. Cohen, and based upon what she saw in that invoice, that's exactly how she knew what to put on the voucher. It also was consistent with what she had understood was happening at the time, which is Michael Cohen was serving as President Trump's personal attorney, which was true. There's not even a dispute about that. And then the checks, right? Oh my goodness gracious, everybody. Blame it on the software. I know. So the checks are on the far side of the screen that you are looking at in front of you or higher up. The information on these checks was also auto-generated from the information put into the vouchers. That's what Ms. Tarasoff told you. And so again, the language in the check documents and documentation is all driven by the vouchers, which is all driven by the invoices. So let's talk first about the invoices. Oh my goodness. Blame it on the AI. I know. Now, some of these invoices were sent in the body of emails. Some were sent as attachments to emails. And you can see examples of both of them here. Every single one was addressed to Alan Weisselberg, care of President Trump. There's no dispute that not a single invoice was emailed or sent to President Trump directly. Now I expect the government will say, well, you know that President Trump saw these invoices because generally speaking, Ms. Tarasoff told you that it was her practice to staple them to the back of the checks before they were sent to President Trump, and she explained how that process worked. But, and again, through no fault of her own, because we're talking about something that happened in 2017, she did not have any specific recollection of whether the invoices that relate to the particular charges in this case were actually stapled to the checks. Oh, that's pretty weak. That's a pretty weak one. She told you about her general practice, but general practice, ladies and gentlemen, is not proof beyond a reasonable doubt, especially when Ms. Tarasoff told you that she never did anything at the direction of President Trump. She never spoke to President Trump about anything to do with especially when Ms. Tarasoff told you that she never did anything at the direction of President Trump. She never spoke to President Trump about anything to do with this. Cohen was rendering services to President Trump in 2017 as his personal attorney. He admitted that. He said it on direct examination. He said it on cross-examination. There's really no question that in 2017, Michael Cohen was serving as President Trump's personal attorney. As a matter of fact, on direct examination, as you can see on the screen, he said one of the reasons why he needed to serve as President Trump's personal attorney was because there was still outstanding matters that they were dealing with, which was true. there were outstanding matters that Mr. Cohen was dealing with on behalf of President Trump in 2017. Here is just one example, and there are others. This is May of 2017 email from Mr. Cohen to Mr. Weselberg. Hope all is well. Please find attached the May invoice and call me to discuss the last open foundation matter. That's in May of 2017. Like, whose case is he arguing? Like, what? Now the government wants you to believe that Mr. Cohen and Mr. Weselberg and President Trump had some kind of agreement, some kind of conspiratorial agreement to falsify the records, that Mr. Cohen was really not working for the $35,000. He was working for free. That's what they have said to you. But here, as you can see, Mr. Cohen is sharing with Mr. Weselberg an invoice and saying, call me, or I need to discuss something I'm doing on behalf of President Trump. Here's another example. There was some litigation-related matter, as you may recall, from someone named Summer Zervos. Uh-oh. Oh, dear. Now, and again, this happened a lot, but Mr. Cohen lied to you. Cohen lied to you on direct examination when he said, in response to the question, how would you characterize the amount of work that you did generally on that matter, if any? Very minimal. But then on cross, when he was confronted with documents, he indicated that he was lead counsel, co-lead counsel on that matter. And in response to a question on whether that was taking a fair amount of his time to work on that, Mr. Cohen said yes. And that's just two examples of what Mr. Cohen was doing for President Trump in 2017. Is this a high school report? It's like a book report. Oh my gosh, I'm sorry, everybody. Outburst. I had an outburst. Hold on. I apologize. He tried to call it minimal. It wasn't. But even if it was minimal, even if the amount of work that Mr. Cohen was doing for President Trump in 2017 was minimal, there was a retainer agreement. And that's how retainer agreements work. You heard that from Mr. Cohen when he talked about all of the other consulting retainer agreements that he had. Do you remember he told you about one with Novartis? Novartis paid him $100,000 a month for 12 months. That's $1.2 million. And he told you he had 6 interactions with them. Anything criminal about that? No. That's the way retainer agreements work. You are on call, just like Michael Cohen was on call with President Trump. All right, everyone, I'm going to stop here. He was on call to take out a line of credit to pay with his own money an adult film star. Let's just make sure we understand that logical connection. With that, I'm gonna have to pause, everyone. All right, I'm getting the feeling that I'm struggling a little bit here. Said to hide it from his wife. Right. I don't know. Oh my gosh. Yes, well, I have been on live here almost an hour and 40 minutes, so I'm going to have to stop right here. And I can tell already my frustration is leading me to put too many of my own comments in here. They told me, you play, you pay. How's this going to last for 4 hours? Very painfully would be my guess. Excruciatingly painfully. So what I do plan to do, as the Navy vet so wisely suggested, which is to go through and kind of pick the highlights such that they are here when it comes to Mr. Blanch's opening. I wanted to kind of get the feel for the flavor, and I think the flavor right now is like, I don't know, kind of like that green Jell-O with that shredded carrot in it. That's the flavor I'm getting right now. Like unpleasant, but like something that you have to go through. Oh, it's getting late, everyone. Anyway, so let me go through and kind of pull out some of the highlights here. Oh my gosh. Yeah, dirty sock flavor. Oh, yes, it's true. I do not care for green Jell-O if it's not done properly. All right. You're getting bored with him. Oh, I know. Much more palatable than this flavor. I don't mean anything negative about that, Mr. Jell-O. I apologize. Another cliffhanger. Oh, I know, everybody. All right, so let me just do a summation here of what I've got going on. So I have the other half of the jury instructions that I would like to, oh my goodness, Daisy, no. I would like to do the other half of the jury instructions, and then I will be reading again through more of these closing arguments. So I do plan to do not only Mr. Blanche's, but of course I've got to read the state's, and I've heard that their closing was amazing. So I'll be reading these in sections and pieces so that we don't have too much all at one time. But I do want to get through those jury instructions. So I am planning to come back again tomorrow, which is Thursday. And again, because we've got the jury deliberating, at this point, I want to stay kind of, in it to win it. So I do want to get through the jury instructions. So I'll come back and we'll do the other half of the jury instructions. And then we'll do a chunk of this closing argument that I think are the highlights here. What do you think of the questions the jury have asked so far? Oh, yes, I forgot, everybody. All right, before I go, hold on. So, real quick, everyone. So the jury here in New York, and this was my understanding, and correct me if I'm wrong, the jury had sent out 2 notes. So the first note they sent out had 4 questions on it. And one had Pecker's call with Trump in 2016. The next one was Pecker's testimony about the financial arrangements related to Karen McDougal. Then we had Pecker's testimony about the October meeting. Are these documents available to the public? Absolutely they are. Yep, you can just go to New York courts online and you'll go to transcripts. You can look at all of the evidence. You can look at everything. It is all made available. And then the fourth one was Cohen's testimony about the August 2015 meeting. So I have pulled out these sections and I cannot read through them tonight. I just don't have enough voice left for tonight, everybody. But I have pulled them out and I will go through what they are. So what I was thinking, would it be helpful if I did just a post to go through these 4 questions? Because I pulled them out. I have here so Mr. Cohen's testimony here and the question for the August meeting, I've got marked here, so I can do that. And then I've got Mr. Pecker's testimony here, and these purple tabs are the 3 questions from the jury there. So I can go through and make a quick little post about those. Okay, yes, please make those. Okay. I'm not going to have enough voice for tonight, but that'll probably be my first thing that I post up for tomorrow then. The jury's due back in the morning, so counsel's still debating on where exactly to start and stop with this transcript that they're going to be giving to the jury. So we should have plenty of time to get it up and running in the morning to go through that. So, okay, well, I will do that. So before things start to get ugly, everyone, I will go ahead and sign off. I can tell. I'm about to lose my voice, everyone. So have a wonderful night. Thank you, everybody, for coming by. Oh, Deborah, it's good to see you. Thank you all. Thank you to all of the amazing moderators that help me out on these lives. Oh, my gosh, I'm so thankful. They do an amazing job. So take care, everyone. Look for that post tomorrow, and I will be back as soon as I can. So have a great night, everyone. Thanks for coming by.